"You are ghetto garbage," the judge said, leaning forward from the bench with the slow, deliberate ease of a man who had never once been told he was wrong. "And this court has no time for ghetto garbage." The courtroom went still. Not the polite quiet of a room waiting for what comes next. Something deeper. The kind of silence that lands on a place when everyone in it knows they have just witnessed something they cannot take back. The boy at the defense table didn't flinch. He was 17 years old, wearing a tie his grandmother had ironed that morning, and he looked up at the Honorable Gerald Whitmore with the calm, steady eyes of someone who had already survived far worse than this man's contempt. He said nothing. He folded his hands on the table in front of him, and he waited. Nobody moved. Not the bailiff. Not the stenographer. Not the row of parents who had come to support him. Nobody spoke. What they didn't know, what Judge Gerald Whitmore, with his 41 years on the bench and his portrait hanging in the county courthouse lobby, could not possibly have known, was who this boy's grandmother really was. He had just made the worst mistake of his entire career. Have you ever been looked at by someone in power and felt, in that moment, like they were seeing straight through you to something they had already decided you were? Stay with me, because what happened next didn't just change one boy's life. It changed the law. Let me take you back, 14 hours earlier. The alarm went off at 5:15. It always went off at 5:15 in the apartment on Clement Street, third floor of the building where the elevator had been broken for 2 years, and the landlord had stopped returning calls sometime the previous spring. Marcus was already awake. He had been awake since 4, lying on his back, staring at the water stain on the ceiling his grandmother called the map. Because if you looked long enough, she said, it looked like it was showing you somewhere worth going. His grandmother, Doris Elijah Webb, was 68 years old and moved through that apartment like she owned every inch of it. The smell of cornbread and coffee filled the hall. She had pressed his shirt the night before, hung it on the back of the bathroom door so the shower steam would keep it fresh. Marcus sat at the kitchen table and she set a plate in front of him without a word. Eggs. Toast. The good strawberry jam she kept on the high shelf for serious mornings. He said, "Grandma, I'm not hungry." She said, "Eat." He ate. Doris Webb had raised Marcus from the age of 4, after his mother passed and his father went away to a place Marcus was too young to understand and too old to pretend didn't matter. She had worked 31 years as a registered nurse at Mercy General, night shifts mostly so she could be home when Marcus got home from school. She had a small garden on the fire escape, tomatoes, basil, a single stubborn rose she had been coaxing through 3 Chicago winters. She went to Calvary Baptist every Sunday and sat in the 3rd pew from the front, the same pew she had sat in since she was a girl, singing every word of every hymn from memory. She also, though she never spoke about it the way some people would have, held 2 law degrees. Howard University, class of 1979. Yale Law, 1981. She had practiced for 12 years, civil rights litigation mostly, the kind that didn't pay well and mattered enormously, before stepping back to raise her daughter and then, when her daughter was gone, to raise Marcus. She kept her bar certification current, quietly. The way you keep a passport renewed even when you have no immediate plans to travel. Just in case. On her keychain, alongside the key to the apartment and the key to the mailbox, there hung a small brass medallion, the size of a quarter. On one side, the Howard University crest. On the other, engraved in letters so fine you needed good light to read them. The arc is long. Keep bending. Marcus had held that medallion 1,000 times. He knew the weight of it. That morning, before they left for court, she pressed it into his hand. "You hold this," she said. "Don't let it go." He closed his fingers around it and carried it all the way to the building with the portrait in the lobby and the broken elevator and the judge who had already decided what he was. The charge against Marcus was, by any honest reading, an embarrassment to the justice system. It had begun 3 weeks earlier with a confrontation outside Northside Academy, where Marcus was a junior with a 3.8 GPA and a letter of commendation from his AP history teacher folded in his backpack. According to the incident report, he had engaged in threatening behavior toward another student. The other student was Connor Ashworth Briggs, whose father was a city alderman and whose uncle sat on the school board. What the incident report did not mention, because it had been quietly revised before submission, was that Connor had been the one doing the threatening, and Marcus had simply stood his ground and refused to walk away. There were 6 witnesses who said so, a lunch monitor, 3 students, a custodian named Mr. Finley, who had been mopping near the door and heard everything clearly, and a sophomore girl named Amara, who had filmed 47 seconds of the incident on her phone before a teacher appeared, and the phone was, somehow, quietly confiscated. None of those 6 witnesses had been contacted by the defense, because the public defender assigned to Marcus was carrying 42 cases that month and had met with his client exactly once, for 11 minutes, in a courthouse hallway. Judge Gerald Whitmore had presided over the Northside Juvenile Division for 9 years. He was 63, heavy-set, with a face that had settled into permanent impatience. He was known among attorneys who practiced in his courtroom for 2 things: the speed with which he moved through his docket, and the particular weight of his contempt for certain defendants. The kind who came from third-floor apartments with broken elevators, the kind who wore ties their grandmothers had pressed. He was also known, though people said it only in low voices in courthouse hallways, never on the record, never loudly enough to do anything about, for the way he talked to those defendants. The small diminishments, the weary sighs, the way he said son or sweetheart or people like you, in a tone that made the words mean exactly the opposite of what they should. The way he looked at certain families in the gallery and seemed to decide, before a single word of testimony, what the outcome would be. Nobody had ever done anything about it, not once in 9 years. But what Marcus didn't know, what none of them knew, was that a clock had already started. A clock that had nothing to do with Whitmore's docket or his underprepared lawyer. A clock set in motion 6 days earlier, when a formal complaint filed by an attorney named Doris Elijah Webb, 412 pages documenting a pattern of racial bias across 47 cases in Whitmore's courtroom, had reached the desk of the Chief Justice of the Illinois Supreme Court. Remember that number. 6 days. The hearing did not go well. It went exactly the way the machinery was designed to go when one side has no real preparation and the other side has a father who is an alderman. Thomas Greer, the public defender, spoke for 4 minutes. He did not call any witnesses because he had not contacted any witnesses. The alderman's attorney spoke for 11 minutes and used the phrase community safety concerns 4 times. Judge Gerald Whitmore listened with the expression of a man performing a task so familiar it required no real attention. He made 2 notes on a legal pad. He took a sip of water. Then he looked at Marcus. And something shifted in his face. Some small, ugly permission that certain people grant themselves when they believe no one of consequence is watching. "Young man," he said, "I have sat on this bench for 9 years. I have seen hundreds of young men sit where you are sitting. You come in here with your little tie and your grandmother back there, and you think that changes what I see. It doesn't change what I see." He leaned forward. "You are ghetto garbage," he said. "And this court has no time for ghetto garbage." The silence came down like a curtain. And then Doris Webb stood. She did not raise her voice. She had never needed to. "Your Honor," she said, "I am Doris Elijah Webb. I am a member of the Illinois Bar, admitted 1982. I am this child's grandmother. And I would like the record to reflect that your comment was made, on the record, in open court, before these witnesses." She looked around the room slowly. "All of it." Whitmore stared at her. He started to speak, and that was the moment the doors of courtroom 7 opened. There were 3 of them. 2 clerks moving quickly, carrying folders. The third was a woman in a gray suit with silver hair cut close, and she moved through that courtroom with the particular gravity of someone who did not need to announce why she was there. Associate Justice Patricia Oakfor Lewis, Illinois Supreme Court. She walked to the front of the room and set a document on the clerk's desk. Then she looked at Marcus and said quietly, "Son, are you all right?" Marcus said, "Yes, ma'am." She nodded and turned. "But you need to understand where that medallion came from. You need to know who Elijah Webb Sr. was. The man whose name now lived in the small brass disc pressed into his great-grandson's fist. Elijah Sr. had been denied entry to the University of Illinois on the basis of race in 1949. He enrolled in a correspondence program instead, earned a paralegal certificate, and for 30 years from a folding table in the basement of Calvary Baptist Church, he helped his neighbors navigate the courts. He never charged a cent. He died in 1977. Before they closed the casket, his wife Geneva pressed the medallion into young Doris's hand. "He carried it every day," Geneva said. The Howard crest on one side, the words he had etched himself with a borrowed tool on a winter evening in 1963 on the other. "The arc is long. Keep bending." Doris carried it through Yale, through 12 years of litigation, through grief, through night shifts, through fire escape gardens and Sunday mornings in the third pew. She had carried it long enough to know it was not a lucky charm. It was a reminder. The arc does not bend by itself. 2 months earlier, during a pretrial hearing in a different case, a case involving a 15-year-old girl from the same neighborhood, Whitmore had picked up the girl's mother's Bible from the defense table, held it up with 2 fingers like something he was reluctant to touch, and dropped it on the floor. "No props," he said. Doris had been in that courtroom. She watched the Bible full. She watched the mother's face. She said nothing that day. But she went home and opened her computer and started building a file. 47 cases. 4 years. Disparate sentencing. Dismissive language. A statistical pattern so clear that the independent analyst the Supreme Court later hired would write in formal language that the results were not consistent with any reasonable interpretation of random variation. Black and Latino defendants in Whitmore's court received custodial placements at a rate 2.7 times higher than white defendants with comparable charges and comparable records. 2.7. Not a rounding error. A system. She submitted the 412-page complaint 6 days before the morning in courtroom 7. She had said nothing to Marcus because she had not wanted him to hope for rescue. She had wanted him to know how to stand up straight in that room, regardless of whether help was coming. Because courage built on someone else's cavalry is not really courage at all. But the cavalry had come anyway. Justice Okafor Lewis presented the Chief Justice's order, effective immediately. Removal of Gerald Whitmore from the bench pending a full judicial conduct investigation. She asked that the full record of the morning's proceedings be transmitted to the Supreme Court within 48 hours. Then she looked at Whitmore. He had gone the color of old chalk. He sat very still. For the first time in 9 years in that courtroom, he had absolutely nothing to say. He looked at the bailiff. He looked at the room. He looked at Doris Webb standing in the gallery with her reading glasses on their chain and the brass medallion. You could just make it out, held loosely in her right hand. He stood. He walked to the side door without looking at anyone. The door closed behind him. Done. Guilty. Gone. In the gallery, a woman began to cry, quietly, privately, the release of something held for a very long time. She was the mother of a boy who had sat where Marcus was sitting 3 years earlier and received a sentence that did not fit what he had done. 2 rows behind her, a man put his face in his hands. Parent after parent sitting in those gallery seats, each of them carrying their own version of that moment. Thomas Greer sat at the defense table looking at his folder with the expression of a man recalibrating everything he thought he understood about this morning. Marcus hadn't moved. He was still seated, still straight, still holding the medallion under the table where nobody could see. He looked at his grandmother. She looked back at him, the very smallest nod. There it is. There is what you were made of. What happened after is what justice actually looks like at its most necessary and most unglamorous, the long, grinding work of accountability. The Supreme Court's Inquiry Board reviewed Doris Webb's file in full. They brought in an independent statistical analyst who examined sentencing patterns across Whitmore's entire juvenile docket going back to 2015. The numbers were unambiguous. Black and Latino defendants received custodial placements at a rate 2.7 times higher than white defendants with comparable charges and comparable records. 2.7. Not a rounding error. Not a bad run. The analyst wrote, in formal language, that the results were not consistent with any reasonable interpretation of random variation. The Inquiry Board also discovered something Doris had documented, but that none of the previous complainants had known. There had been 2 earlier complaints filed against Whitmore, in 2019 and 2021. Both had been reviewed and quietly closed. The investigator assigned to the 2019 complaint had been a personal friend of Whitmore's. The public defender who filed the 2021 complaint had been denied reappointment to her office 2 months later. Nobody had connected the dots because the dots existed in 3 separate bureaucratic systems, and because nobody had assembled them into 412 pages. Whitmore was removed from the bench in March of the following year. Permanently. Not retired, removed. The findings cited a pattern of racially biased conduct spanning 4 years, conduct unbecoming of a member of the judiciary, and one specific line, quoted in full, exactly as the stenographer had transcribed it that morning. You are ghetto garbage, and this court has no time for ghetto garbage. That line became the headline in every paper that ran the story. It became the hashtag ghetto garbage, that trended for 9 days and generated 400,000 replies from people sharing their own stories. Parents, students, workers, people who had sat across from someone with power and felt the same invisible verdict being handed down before a single word was spoken. The original news report was shared more than 2 million times. The comments section had 11,000 entries 6 months after publication. The law firm of Chen Obaseki and Franklin opened a class action case on behalf of 43 families whose children had received sentences in Whitmore's court. Settlements reached $2.4 million before the first trial date. The county's juvenile justice system was placed under a federal monitoring agreement requiring independent oversight of all sentencing decisions, the first such agreement in the county's history. The school district settled separately after an investigation found that incident reports had been quietly revised 19 times in 4 years in cases involving students connected to school board members. The deputy superintendent who authorized the revision policy resigned. Connor Ashworth Briggs's uncle did not seek re-election. Thomas Greer testified before the state legislature's Judiciary Committee. He brought his numbers. 42 cases a month, 11 minutes per client. 12 hours total, he told the committee, to represent 42 human lives before the courts of the state of Illinois. The legislature allocated $6.8 million to the public defender system in the following budget cycle. Not enough, not nearly enough, but more than it had ever received. A beginning. A first bend in an arc that had been straight for too long. Marcus Webb's case was dismissed. Formally, completely, with a finding that the original complaint rested on a falsified incident report, submitted to a judge whose removal was pending on grounds of bias. Every record sealed. Every document expunged. 1 year later, the Elijah Webb Community Legal Clinic opened 3 blocks from the apartment on Clement Street. Free legal representation for families with children in the juvenile system. A partnership with Howard University Law School for supervised clinicals. In its first year, 209 cases. Doris Webb ran it. She ran it the way she had run everything, with absolute steadiness and no interest in credit. She still went to Calvary Baptist on Sundays. 3rd pew from the front. Every word of every hymn. Marcus graduated from Northside Academy that June and gave the valedictory address. 3 minutes. He thanked 2 people by name. Thomas Greer, he said, had taught him without meaning to that the system's failures were not inevitable. They were the product of choices, and choices could be unmade. And then he thanked his grandmother. He said, "She gave me something to hold on to, and she taught me that holding on is the work. The rest takes care of itself." He enrolled at Howard University that fall. He carries the medallion in the front pocket of his jeans, where he can feel it. He takes it out sometimes when things are hard and turns it over in his fingers. The Howard crest on one side, the words on the other, the words his great-grandfather carved into brass with a borrowed tool in 1963, an act of faith in a future he could not have been certain he would live to see. The arc is long. Keep bending. If this story moved you, if you have felt the weight of being dismissed by someone with power and still found a way to stand, please like this video, share it, subscribe, and hit the bell so you never miss a story like this one. And tell me in the comments, have you ever been written off for how you looked or where you came from? What did you hold on to? Here is what really gets me about this story. It is not the removal. It is not the settlement. It is not even the Supreme Court order, remarkable as that was. What gets me is a 68-year-old woman who for 4 years, in silence, kept a file. Who watched a Bible get dropped on a courtroom floor and went home that night and opened her computer and started building a case instead of giving up. Who pressed a brass medallion into a boy's hand on a serious morning and sent him into a room that was not designed for his survival. Who sat in the gallery in a navy dress and waited with the patience of someone who had spent a lifetime learning that the right moment comes only to those who are ready for it. 40 years of preparation. For a morning she prayed would never come. What is your version of that file? What are you quietly, patiently building in the dark? The work no one can see yet. The arc you are bending in private. Tell me, because I believe that is exactly where justice actually lives.